Right. Good morning, everybody. Thank you for joining. We have David Korman once again with his infinite knowledge, and he's going to put some light on assignments today, which is a very big part of pre-construction. We did a session on pre-construction a couple of weeks ago with him. So this is kind of an ongoing thing that I'm trying to build up more information and knowledge of pre-construction within our brokerage. And assignments are a tough one. So this is a two-part series that David will do. One will be today, and the other one is to follow next week, same time at 11:30. So I'll give it over to David now.
Okay, thank you, Sabiha. And I like the way that Sabiha refers to everybody in her emails as summiters. I think that's advice summiters. I think that's sort of a neat thing. I think David uses that as well. So welcome to all the summiters. Always great to be with you. Like Sabiha mentioned, we're dividing this into two parts. You'll see why as I go through it. I'm going to try and finish by 12:30 today, and then we'll do the second part next week. Assignments are difficult, and there's a lot of material. There's a lot of issues. So I don't want to scare you. You're here for a reason, and that's to learn about this and to learn how to do it properly. So this is to give you some information because they are difficult. They're really difficult, and there's a lot of different factors that you'll see that go into it. So that's why I'm going to be speaking fast. I'll be going through a lot of information. I'll take questions at the end, and we'll do half of it today and the other half next Thursday at the same time. So I'm going to share my screen, and hopefully you'll be able to see that. Sabiha, can you just confirm that you're seeing it?
Yeah.
It's got the assignments, part one?
Yeah, we have it. It's just maybe you have to do a full screen because we're right now. Yeah, slideshows are about to.
Okay, so are you seeing it as a full screen?
Yeah, that's excellent.
Okay.
Perfect.
So this is, like I said, part one. And we're talking about acquiring the right to assign a pre-construction builder agreement of purchase and sale. And that's what I used to look like before COVID. And the areas of practice I think you're familiar with. In our office, real estate, corporate, commercial, wills and estates. And at our three locations, Mississauga, Toronto, Markham, plus remote locations, like I'm in Richmond Hill. This is my Richmond Hill office during COVID. And by the way, everybody will get a copy of this. We'll send it to Sabiha, and you'll be able to get a copy of this. So let's get to it. So part one, what we're going to be covering today is buyer acquiring the right to assign a pre-construction agreement of purchase and sale. And I'm going to refer to that as a builder's agreement of purchase and sale. We're going to go through some conditions that might be imposed by a builder in order to give those rights to assign, because they always impose certain conditions with it. And then we're going to look at some of the tax issues that come up, and you'll see why assignments get confusing and are difficult, because there are land transfer tax issues, HST rebate issues, income tax, capital gains tax issues that come up. So let's start with the builder's agreement of purchase and sale. So it's always important from an agent's point of view, from a lawyer's point of view, you got to read the builder agreement of purchase and sale. It's part of your job, your responsibility as an agent. And then ultimately when we get it as well, we want to make sure that we get the full agreement of purchase and sale, including all schedules and amendments. A builder's agreement of purchase and sale is sometimes about 20 pages long, a fine print, and then there's a bunch of schedules that are attached to it. Some are mandatory, some are schedules with color schemes, with subdivision agreements, all kinds of different things can be in schedules. We've got to make sure we get the whole package. There's upgrades, color charts, there's amendments sometimes. So it's very important. We want to see there's evidence of compliance with deposit insurance. We talked about that last time on a condominium transaction. The deposits that are paid to the builder are covered with insurance as long as they comply with the provisions of the Condominium Act. So the evidence of compliance, so if these deposits are protected, are part of the documents. We want to make sure we've got that. And if it's a condo, there's also disclosure documents that have to be provided by the builder. And that could be a book that's, that's 4 inches thick with documents on the condo to be built. These days, sometimes that's sent electronically, but we got to make sure we get the full package. Now, part of what we have to do is to check and make sure things are correct. We want to make sure we've got the correct names right from the start. If the correct names as buyers aren't there, we've got to go and get an amendment done or look to getting an assignment. Some builders don't want to do that. They don't like assignments generally, and you'll see why in a few minutes. But it's important for us to make sure, is it going to be husband and wife that are taking title? Is it going to be just one of them taking title? Do they want a kid on title? Do they need somebody else on title for mortgage purposes? We want to tackle that issue right from the beginning, okay? Because there are restrictions in the agreement of purchase and sale that'll prevent us from just directing the title. If the buyer was just the husband and they decide they want to take it to husband and wife, sometimes they're allowed to do that because they can just direct title that way. Sometimes they can't. We have to look to see what the builder's agreement of purchase and sale says about that. So we've got to tackle this right up front. So we want to take a look in particular at two clauses. One that would allow a redirection on title, which means that the buyer can say, I'm just signing a document, a direction saying I want to take title in my name and my spouse's name, and that might be permissible. Or do we have to look at an assignment clause to see if we need to invoke the assignment clause in order to assign the agreement of purchase and sale from the husband to the husband and wife? Okay, so we want to tackle that up front and make sure that we do have the right to direct title or assign it. So that's where it's important for you to not only understand this, look for it yourselves, but get a lawyer involved right away. And I refer to a consult with a qualified solicitor. And obviously you can read into that, Korman's LLP are the only qualified solicitors in the province of Ontario. A free commercial message. So obviously that's not true. I respect a lot of people in our profession, our bar, but I also don't have a lot of respect for some people in our profession or bar. The important thing from your point of view as an agent, you got to make sure you get somebody qualified. So obviously, you know, come to our firm. We do these all the time. We've got 5 lawyers available that'll review it. Generally, the same day we get them in is our policy, to try and review them the same day that we get these in. But no matter what, you make sure that you get this to a lawyer to review. Okay. We're going to look at the assignment clause that's in there to find out if it's allowed or prohibited, and are there charges and are there conditions. So just back to a redirection on title. Sometimes the builders allow that, just you can direct, the buyer can just direct title to an immediate family member. They have no issue, but there has to be a clause in the agreement that says that you're allowed to direct title to an immediate family member, a spouse, parent, child, siblings. So we don't need an assignment to do that. We just need a direction retitle, which is the buyer saying, I hereby direct title to go into my name and my wife, or my name and my wife and my child. And by child, I mean adult child. Okay, so if there's a provision in the agreement that allows a direction, that's great. We got to make sure that we see that. If there isn't, then we want to get something put into the agreement to allow a direction for title or an assignment if possible. Now, if it's a condo situation, a lot of times there's a time frame in which you can direct title, and sometimes the builders are saying, we're allowing you to direct title, but you have to do it by the occupancy date. And you can't do it after the occupancy date. And if it's after the occupancy date, you can only do it by way of an assignment, which is a whole different process, much more complicated and much more expensive. So we have to look at the timing for permitting us to do that as well. Okay. Now, sometimes you get into a situation where there might be one spouse that's named as the buyer, but for mortgage purposes, they need to add the other spouse, or they need to add another family member. So a lot of times the lenders say, well, you need to have more people added to the title, but we don't want you to do it just by way of a direction retitle. In order for them to process and go through their underwriting, they insist that an amendment be done, so that we're actually amending the agreement of purchase and sale so that the buyers become the 2 or 3 people that are needed for mortgage purposes, which means you've got to go back to the builder to get an amendment and they've got to sign off on it. And we can't simply do it by a direction retitle. So if title can be directed, that's the simplest thing. That's great. We just got to let the builder know and make sure we do it in a timely fashion. So that's direction retitles. Now we're going to talk about assignments and whether or not they're permitted or not. So generally, you should understand where the builders are coming from. Generally, the position is they don't want assignments. And if there's going to be, so usually there's a clause in there saying, no, there is no assignments, period. Now, then a builder sometimes through negotiation with your assistance, they might say that we'll allow an assignment, but only with the builder's consent. And it'll clearly say the consent is required. Sometimes it'll say that the consent of the builder may be arbitrarily withheld. Okay, which means you can ask for it, the builder can say no, and there's nothing you can do about it. So we have to look at the actual language in it. And you have to understand where the builders are coming from. They basically hate assignments. It's an inconvenience for them. It adds extra paperwork, administration time. A lot of times there's requests for assignments. They start going through the process and then they fall through.
Sorry, David, just 1 second. Can everybody unmute their screens just till David is done, and then we can open the forum for questions, just so that we don't have, I'm having trouble understanding David because of the other sounds.
Yeah, okay. So one of the reasons they hate assignments generally is that it competes with their sales. Okay, so they don't want, they've sold already to a buyer, and they don't want that buyer or a bunch of buyers then going out to flip their properties while they still have an inventory that they're trying to sell. So that's why there generally is a prohibition on assignments. And then we're just trying to find out, well, under what terms and conditions will the builder consent to an assignment? So when we're doing an assignment with a builder, there's 2 documents that have to be negotiated and executed. And this is really important for you as an agent, because you're acting either for the assignee or the assignor on an assignment, okay? So one agreement that you have to negotiate is the assignment agreement of purchase and sale. So this is the agreement that's going to be between the original buyer, who's the assignor, and the new buyer. And you as an agent will be acting for one or the other on these. And obviously there'll be another agent acting for them. So that's one document that has to be negotiated. And a lot of our focus in next week's seminar is going to be how to prepare and that specific agreement and issues to look out for in drafting and clauses dealing with that. So we're going to focus more on that next week, but it's very important. That's one of the documents. The other document that has to be negotiated and signed is a consent agreement between 3 parties. We need the builder, the assignor, and the assignee, because there has to be an assignment, the agreement between the assignor and assignee that the agreement purchase sale is being assigned, and we need the consent of the builder. So all 3 parties have to sign that agreement, and they're going to do that with the advice of their respective lawyers and the agents that are involved. So when a builder is going to consider giving their consent, they're going to impose certain conditions. The first condition you should be aware of is generally the assignor is not going to be released. And that'll be made very clear in that consent agreement between the 3 parties, where the builder is going to consent to the assignment, but they're going to make it very clear in that document that the assignor is not going to be released. So the assignor stays on the hook. Okay, and this applies on resale transactions too. A lot of times the assignor stays on the hook until it closes. So if the assignee defaults, the assignor is required to close with the builder or indemnify the builder. So the builder is saying, I'll consent as long as it goes through and as long as the assignee closes. But if the assignee doesn't, I want the right to not only sue the assignee for default, but I want the right to sue the assignor for the default. So you've got to make sure that your clients are clear on that point, that just because they've signed an assignment agreement doesn't mean they're off the hook with the builder until the closing takes place between the builder and the assignee. Second condition that's generally imposed by builders is they want to get paid for consenting to the assignment. And we've seen them impose assignment fees anywhere from $2,000 to $50,000. And the $50,000 is not a typo, that it should be $5,000, which is sort of a more normal range. We had a situation almost a year ago on one project. We acted for two different buyers, and we went to them for a consent to an assignment. One of them, the builder consented to for $3,000 fee. And within a few days later, we went back to the builder for a consent, and the builder said, we'll consent, but the fee is $50,000. Now, in the language in the agreement, they had the right to come up with whatever number they wanted to. And no matter how hard we argued, you just consented for $3,000 for somebody else. Why aren't you doing it for this person? The builder gave us a list of reasons, which they don't really have to justify because it's totally within their discretion. And they didn't like the way the buyer was handling things. They thought there was a whole bunch of reasons, but nevertheless, they insisted on the $50,000 assignment fee. And after arguing back and forth and thinking we're being as persuasive as possible, we got nowhere. And our client agreed to pay the $50,000 to get the assignment fee because it was the only way to do it. It was still profitable for our client to sell it because there was a premium or a profit that he was making, but it cost them $50,000. Now, one of the things we look at when we get a chance to review these clauses up front before they become firm is we try and negotiate things right up front to put a cap on what an assignment fee might be. So it won't be more than $2,000 or $5,000. And sometimes we're successful in doing that, sometimes we're not. Sometimes, the agents, when you're negotiating it, sometimes you can get that a firm amount or a capped amount put in there. They also want to get builders want to get their legal fees paid for. So their lawyer, the builder's lawyer, is going to be drafting that three-party agreement for the consent. So they want somebody else to pay for their lawyer fees. So oftentimes that'll be somewhere between $500 and $2,000 just for negotiating that three-party consent agreement. So that's going to be paid for either by the assignor or the assignee or split between them, but it's definitely not going to be paid for by the builder. Okay, so that's another cost that everybody has to be aware of. Now, advertisement is another condition that's often imposed. Most builders, even if they're consenting to an assignment, will not allow advertisement for the assignment prior to the final closing. Okay, and that's in a condominium transaction, there's a final closing. And the language in the assignment clause will specifically say that, even if we provide the consent, you cannot advertise it. And that includes MLS, Facebook, LinkedIn, Twitter, Instagram, WeChat, any social media. They're basically saying we're consenting to you signing it, but we're tying your hands about how you can do it. So you're fine if you're going from, you spread the word around within your office from one Sutton agent to another to say we've got this assignment going on, but you can't advertise it on social media. So you've got to find another way to get the word out. And if you violate that provision and do advertise it, like the builders are looking for this all the time. They're checking the social media and they're checking all the multi-listing services for this. And we will get a nasty letter from their lawyer saying you have to cease and desist immediately. You're technically in breach of the agreement of purchase and sale. So the builder has the right to terminate the agreement of purchase and sale and forfeit the deposit, and they can reserve the rights to sue the original buyer for damages. So if you got to this point, you're not going to get a consent to an assignment because you've really upset the builder. Now, usually we get that letter, we say, as long as you stop the advertising and agree not to do it anymore, we won't terminate you. So at least you don't lose the deposit, etc. But they do have the right to completely do all that if there is advertising. So you have to be very careful when you're acting for the original buyer about how you're going to advertise this. Even if you get a consent, how are you going to do it? And don't infringe on this prohibition. Now, sometimes builders say, okay, we're going to permit an assignment, but we don't want you to just use your own real estate agent. So this is bad news for you guys. And you can only assign it if you use our designated real estate or brokerage. And they go through a process that way, because obviously the builder is getting some sort of kickback in doing so, and they set that out. They set that up. So that's basically cutting you guys out of the picture to some extent. So we have to look at that, and we obviously, if we see something like that in there, it's something we want to try and negotiate out. Now, we'll just talk about the timing of permitted assignments for a second. There's a difference whether it's a new condo or a new house, because for a condominium, there's two closings. There's an occupancy closing and a final closing. So we have to look to see if the language says you can only assign prior to the occupancy closing, or are you allowed to sign it during the occupancy period, which means from the occupancy closing until the final closing, or can you assign it on final closing? Once you close, you can do whatever you want. So this is always, prior to closing, when is your right to assign? Okay, if it's a house, you can assign prior to closing or on closing. After closing, anybody can do whatever they want with it. But we have to look at the differences on that. So another issue that I'm raising here as sort of in the conditions section is the HST new housing rebate. Now, I think those of you that attended this webinar heard the discussion about the significance of that. Now, generally, that rebate is available to a buyer who, when they sign the agreement of purchase and sale, was going to buy the property for their own purposes. So on closing, they'd be eligible for the HST new housing rebate. An issue comes up when you're doing assignments about whether or not there would be a qualification for the HST new housing rebate. So because it's questionable, some builders just automatically say, we don't want to be involved in that. So if we're going to consent to an assignment, that is going to, we're only going to do so on the basis that we're not involved at all on whether or not the HST housing rebate is available or not. So we're going to insist on being paid an amount equal to the rebate amount on closing. We're not going to provide you with a credit on closing for the rebate amount. And it'll be totally up to the assignee to apply on their own for the HST new housing rebate after closing. They just don't want to play the game about whether or not they qualify or not. And what happens here is the assignee who wants to buy the assignee might want to buy it for their own purposes and would absolutely qualify on their own behalf to get the new housing rebate if they had bought directly from the builder. But CRA doesn't look at things that way. They look at the intent of the original buyer, the assignor. And did the original buyer, when they signed the agreement of purchase and sale, were they intending to live there themselves? Would they have qualified for the HST rebate? Because if they wouldn't have qualified because they were buying it on spec and they're always going to flip it and they're never going to move in, then that taints it for the assignee. So even though the assignee could have qualified, the assignee will not qualify because the assignor would not have qualified. So the builder just takes the position, put their hands up, say, I don't want to get involved in this. If the assignee is eligible for it, you can apply on your own after closing, but I want the assignee to pay me an amount equal to the HST housing rebate on closing. Whoops, went the wrong way. So we're going to talk about some other tax considerations now as well. So that HST rebate is sort of the new one, the first one we did, but there's also land transfer tax issues, HST issues, which are different than the HST new housing rebate issues. There's income tax issues and there's capital gains tax issues. So in terms of land transfer tax on an assignment, the land transfer tax is payable on the final closing with the builder, and it's going to be payable by the assignee, not the assignor. The assignee is the one that's closing the transaction with the builder. So the assignee has to be prepared to know that they've got to pay the land transfer tax. A lot of times they're asking the agent to give them an idea or let them know how much that's going to be. When we're involved, they're asking us as solicitors to help them calculate that. But the amount is payable on the value of consideration. That's what the Act provides, the value of consideration. So the value of consideration isn't just the purchase price. So it's not just the purchase price that the buyer is, or not, and that's not the original buyer, it's now the assignee is going to be closing with the builder on. Okay, now in an agreement of purchase and sale with a builder, the purchase price is usually a stated price, but it usually includes HST. So we have to back out the HST amount from that for land transfer tax purposes. But then there's other adjustments, other costs that we went through in the last webinar that are passed on to buyers in addition to the purchase price. So those amounts have to be added in, and that could be $5,000, $10,000, $15,000 of adjustments that have to be added in for the purpose of calculating land transfer tax. Okay. Now, an example that I put in here, let's say the purchase price for the builder agreement of purchase and sale is $400,000, which is the price less HST plus adjustments. But under the assignment transaction that you're involved with, the assignor is selling it for $500,000. So there's a $100,000 profit that he's trying to make on the assignment. Now, when we get the deed from the builder's lawyer, it's going to show, normally it would show that it's a $400,000 purchase price because that's all we're really paying the builder. So land transfer tax would normally be paid on the $400,000. But that is wrong. The lawyer for the assignee should be correcting this with the builder's lawyer, because the assignee is really supposed to be paying land transfer tax based on the assignment purchase price, the $500,000 purchase price, not the $400,000. So we have to go back to the builder's lawyer and say, correct this on your deed. You still have to show a deed at $500,000, even though your statement of adjustments shows a purchase price of $400,000. Because for land transfer tax purposes, there's an obligation of the assignee to pay on the higher amount. And there's a lot of lawyers that have not been doing that, and it's wrong. And the builder's lawyer is sometimes not going to do it unless they're asked to do it. And eventually these things get audited, and the government comes back to the assignee and say, hey, you didn't pay land transfer tax on $100,000 of your purchase price. And that was 4 years ago or 5 years ago. So now you owe us the land transfer tax plus interest plus penalties. And that assignee is obviously upset, and they want to go back at somebody. So they're going to look at somebody to blame. They're going to blame their lawyer for sure. They might go back and blame the agent because the agent never explained it to them or they didn't understand it as well. So we always want to avoid those situations. You want to make sure people are counseled properly. Okay. The land transfer tax first-time home buyer rebate is available on assignments. Like, there's no reason, if this is their first purchase and they otherwise qualify and it happens to be an assignment, then as a first-time home buyer, that rebate is available. So you should know that as well, and you can pass that information on to your clients. Okay, so let's talk about HST for a minute. So HST, the general rule of thumb is that HST applies to everything unless there's an exception for it. So for used residential property, there is an exception that HST is not applicable on used residential property. That's why when you're doing your standard resale agreements, you're not really putting your minds to HST because no one is paying HST. There's a clause in the standard form that says HST is included or not included, but if it's used residential, it's not payable because there's an exemption. And the lawyers on the closing are exchanging a document confirming from the seller that it's a used residential property and therefore there's no HST payable to the government. So that's an exemption for used residential property. There is no exemption for brand new properties, for new construction, whether it's a condo or a house. It is subject to HST. So we've got to take a careful look at that and make sure everybody's aware that it is subject to HST. So if it was a $1 million purchase, then you have to pay 13% HST on that $1 million. The good news is with almost all builder sales, there's a provision in there that the price that they're showing you as your purchase price is inclusive of HST. Okay. So just be aware of that. This way. So the HST is inclusive, generally. Again, the solicitor review is always very important, but in addition, I encourage you to have an accountant review any of these assignment transaction as well. You know, me as a solicitor, I can review certain things, I can provide certain advice. I'm not qualified as a tax expert, even though I have some knowledge about HST rebates, about HST, about capital gains, about, you know, I have some knowledge that I'm going to pass on to you today, but I'm not a tax expert, and most real estate lawyers are not tax experts, although we're familiar with should be familiar with these concepts. It's oftentimes very useful to have an accountant, and specifically a tax accountant, get involved in this for their input as well, okay, for all these potential tax issues. So, and HST is becoming a real issue with people, and CRA is becoming more and more aggressive in looking at this and whether HST is payable or not payable.
I'm all on my own.
Somebody's on there. Now, if somebody's in the business of flipping properties, CRA will generally say that they're in that business. This isn't a one-off assignment, and they're going to say that HST is payable. And here I'm talking about whether HST is payable on the assignment transaction itself and on the profit part of it. Okay. So it's pretty clear right now that HST is payable on the profit. So in that scenario I was giving you a minute ago, if there's a $100,000 profit that the ASNOR is trying to make, HST is payable on that $100,000. Okay. So because it's payable, that's something that's going to have to be negotiated in your assignment agreement, purchase and sale. Who's responsible to pay that HST? Is it the ASNOR or the assignee? What's really unusual on assignments is CRA is even more aggressive. It's sort of understandable for them to charge HST on the profit, but they've gone beyond that. And they're saying we want to charge HST on the deposit as well. And this is on the original deposit between the original buyer and the builder. So if there was $100,000 in deposits, a lot of times on these projects, there's a series of deposits that have to be made. And sometimes it's 4 or 5 deposits they're making over time. But let's just say it's $100,000 that it all adds up to. So on an assignment transaction, the ASNOR wants to get repaid the deposit money they've given to the builder. So the assignee is going to be repaying them that money. The assignee takes over closing with the builder. And then there's hopefully a profit there as well. So the CRA is taking a very aggressive position that we want to charge HST on not only on the profit, but on the deposit amount that was paid to the original builder. To me, this makes no sense because it's just, the money has gone to the builder. It's just a replacement by the assignee of that money. The assignee is just paying that money back to the ASNOR. The builder is still holding. It's the same money. But the CRA is looking at this as an opportunity to collect HST on all of those deposits. So eventually this will get litigated and appealed through the tax courts. But right now it hasn't been. So you have to be aware of that. So there's that potential liability to pay HST on the profit amount and the deposit amount as well. So we'll go back to the new housing rebate as well. And CRA is also being very aggressive and cracking down on this. So like I mentioned before, in them determining whether or not there's eligibility for this new housing rebate, and this rebate is usually in the $24,000 range, so it's not an insignificant amount of fund. They look at the intention of the original buyer, the ASNOR, not the assignee. They want to know that the assignee is moving in and living there for their own purposes, so they would qualify, but that's not enough on an assignment transaction. They go back to see what the original intention of the ASNOR was at the time. And we're going to talk about this more next week in terms of clauses that we need in the agreement, because we need a specific clause in an assignment agreement where the ASNOR is providing a representation or a warranty saying, when I originally signed my agreement, I would have qualified and I was going to live there myself or an immediate family member, so I would have qualified, because that's very relevant for an assignee to know, so they can rely on that so that they can qualify for this rebate. Okay, so we have to look back to that intention of the original buyer. So otherwise it's tainted, and there's nothing that the assignee can do about it. So we'll discuss more on that next week. But the CRA, when they're looking at this, they're looking for a way not to provide the rebate. They're trying to be very aggressive. So if you give them any out, or if they have any indication that there may not be a qualification, they're looking for a way out. So if an assignor is a corporation, the CRA is not going to provide the new housing rebate on it, because the corporation can't, as original buyer, occupy it for their own purposes. It's not an individual living there. If it is an individual there, but the CRA sees they've purchased several units and they're generally in the business of flipping them, they're not going to allow it as well, because they're going to say, no, there's no way that original buyer intended to really live there. They have a history of buying and selling these new construction properties, and that's part of their business. So so that's going to taint it for the assignee as well. Okay, so if it is tainted or they're not qualified, then the assignee is going to be required to pay the builder an amount equal to that HST rebate on closing. So that could be $24,000 that the assignee has to pay on closing, in addition to the purchase price, to the builder. And then the assignee, after closing, can apply to see if they're eligible. And even if they were eligible on their own, as I've said, they may not be eligible if it's tainted by the assignor. So because there's these issues, you'll see again next week when we get into this, there's clauses that we're going to assist you with to put into an agreement to try and flush out these issues right up front, because somebody's going to be paying $24,000 to the government, either the assignee or the assignor. And we don't know, or we may not know, whether or not they're going to get it back from the government. Sorry, someone's going to be paying the $24,000 to the builder. What we don't know is whether they're going to qualify to get the money back from the government. So is it the assignee that's going to have the responsibility to pay that, or is the assignor going to be paying that? Now let's move on to income tax and capital gains tax implications. The assignor is generally on an assignment going to hopefully making a profit. So the question from a tax point of view, is that profit going to be claimed as a capital gain, or is it going to become income? Because maybe it's income because they're in the business of flipping properties or doing these on a regular basis. So again, that's something where I couldn't, or as a lawyer, give them proper advice on, and that's where their accountant or tax advisor has to be brought in to figure that out for them. Okay, so that's an important issue, because they have to know, because they really want to know what's their after-tax position going to be if they do this assignment. Now, if the assignor is a non-resident of Canada, tax has to be paid on the income they received from sources in Canada, which would include any profits they made on assignments. So that has to be addressed. Section 116 of the Income Tax Act comes in, and that's the provision that says anybody that's that's a non-resident of Canada can't get their money taken out of Canada when they sell a property in Canada until they comply with this provision of the Act. And it's basically an opportunity for the government to review their affairs and make sure they don't owe any taxes before they allow the money to be released. So there's a holdback requirement from the proceeds of sale that have to be held back until a certificate is issued by the CRA confirming that there's no taxes owed, or that there's a certain amount of taxes owed, and they require an amount paid from the sale proceeds to pay those outstanding taxes. So that's another consideration that has to be dealt with. Okay, so the type of tax and requirement to file income tax depends on the type of income that's being received. So this again is where you need a tax accountant to be consulted to deal with these various taxes. So it's something you've got to alert an assignor to. And the other thing to let an assignor is responsible for paying these taxes. But if you're acting for an assignee, you also have to be aware that even though it's the assignor's liability to pay these taxes before the money leaves Canada, the assignee is the one that has a liability under the Section 116 of the Income Tax Act to make sure that the assignor complies with this and that there's a proper holdback. So it's the, I know this gets confusing, but it's the assignor's liability to pay the tax, but the responsibility goes to the assignee to make sure there's a proper holdback. So there's money sitting in Canada that can be used to pay the outstanding tax. And if they don't, if there isn't a proper holdback, then the assignee becomes responsible for the taxes payable by the assignor. So again, this is another point where it's important to have proper legal representation involved to make sure there's a proper holdback. And the holdback in most cases is 25% of the sale price, but depending on the type of property, sometimes it's 50%. And we've been involved in many situations where we're acting for a seller, and I've had another lawyer ask me to hold back 25% of the sale price, and we undertake to do so, and they send us the docs, and we agreed to do so, but I know that it's wrong because it really should have been a 50% holdback because of the type of property. So it's important to get proper advice on these things, and some agents, some lawyers aren't aware of when it's 25%, when it's supposed to be 50%. So that's important as well. Okay, so moving along. I've got through this about as fast as I can, and I'm trying to leave some time here for questions as well. So I've covered basically what I wanted to cover today. I just want to show you what we're going to be talking about next week in part 2. So next week, we're going to focus on negotiating the assignment agreement of purchase and sale, how to prepare it, how to negotiate it, what are the important provisions and considerations for that. So we're going to look at the assignment deposits, which are these deposits paid as part of the assignment transaction, which is different from the deposits that are being paid to the builder, because they both have to be accounted for. We're going to go through various conditions that should be included in this assignment agreement of purchase and sale. We're going to discuss the assignment fees and costs to the builder. I touched on that a little bit today, but this will help you out in terms of the negotiation of who's responsible for paying these fees and other costs to the builder, assignment fees, and some of these other adjustment costs that we talked about in the last webinar. Is it the assignee that pays those to the builder, or is it the assignor that pays those to the builder? And that's all like the builder's closing costs, because it's not just the purchase price, there's all these other adjustments. Who's responsible for paying that? We'll discuss what's the proper closing date for an assignment. Does the assignment have to close on the same day that the builder's agreement of purchase and sale closes, or can it close earlier? An assignor just wants to get their money as soon as possible and close. They don't want to hang around till that final closing date, but there's certain factors that'll determine whether or not you can close earlier, or do you have to wait for the same closing date with the builder. We're going to look at specifically at Schedule B of the standard form of assignment agreement of purchase and sale. For anybody that's already done one of these, it's one of the most confusing schedules, even though it's basically it should be a simple form, but it becomes so confusing. So we're going to go through a little bit how you should be completing that, line by line, with, what are the right numbers to go in line by line in that. So we'll do that with an example. And we'll also go through the process that you have to go through for completing an assignment of agreement of purchase and sale. What happens, because there's really two transactions that are happening simultaneously. One is the assignment transaction and one is the builder's transaction. What's the process? What's our role as lawyers? What's your role as agents? How can you still participate and help out in the process? And you have to understand that. And then we're going to go through some specific drafting issues, and I'm going to give you a whole bunch of clauses that should be considered. One list of clauses we've got and we'll give you all these clauses as part of it. One is from an assinor's point of view, and one's going to be a list from an assinee's point of view. And we'll discuss the relevance of these clauses and when they should go in, when they shouldn't go in to some extent. And then at the end, we'll discuss a little bit of why assignments die, and and what are the things to look out for, and why they become problematic. And the reason we do that is because we want to avoid them from dying. We want to keep them going. So we have to be aware of the various issues that could kill your deal, because if your deal gets killed, I'm telling you, you're spending an awful lot of time on these assignment transactions, and to go that far through them and then they die because of one of these issues, you're not getting paid. So that's never a good situation for you. And even though you're used to it on any transaction, any resale transaction, no matter how much effort you put into it, if the transaction doesn't close, you don't get paid. You only get paid on successful completion. So that's true in an assignment transaction as well. And we don't want you to lose any commissions. We want to keep these deals alive. So we want to be aggressive in knowing what the potential killers are for these deals and make sure we address them as we go through the process so they don't die on you. So that's where our focus is going to be for tomorrow. So I think you can see, because I think I covered this in about 50 minutes, 45, 50 minutes today, but I need at least that much time for next week's session, or probably a full hour to do that. And that's why we divided this in two. It's a lot of information. And I wanted to leave at least 10 minutes today to answer any questions that you might have.
David, I mean, this is really helpful, and I see that you have something that I want to mention is, I think it would be really helpful, because what I've been trying to do is kind of get templates ready for everybody to use for both ends, so that there's no mistakes and no confusion at the end of the, because what happens is we go into webinars, we learn all these new things, and then we forget when we're actually putting an offer together. And it's not often that we do an assignment. So it would be really awesome to actually go in, say, these are the forms that are required, and this is what it should be for a listing of an assignment and the sale of so both ends of the assignment.
Yeah. Well, I'm going to leave the listing part to you.
Right.
But we're going to go through the actual assignment agreement, the standard form. So we're going to take a look at that, in particular Schedule B, because that's the part that
has the details in it. Yeah.
And then give you all the clauses that should be added in the schedule, either from an assinor's point of view or from an assinee's point of view. And those clauses are all designed to cover off the issues that we were talking about today. Responsible for paying these things, HST, new housing rebate. We need certain reps and warranties from an asinor that they would qualify, like those type of things. So we've got clauses that you can put in from an assinor's point of view or from an assinee's point of view to cover off those situations and to make it clear who's responsible for paying what and things like that.
Any questions? Guys, you can unmute and go ahead. It's open to everybody. It's an open forum. So go ahead and ask questions if you have any.
While we're waiting for, I'll just show you my last slide here, just to point out for you, in case anybody's not aware, but we've been advertising this for a while in social media, that we will provide 25% off our legal fees for any frontline workers. So, and we've got a very, wide interpretation of a frontline worker, but we're very honored to offer this to anybody. So if any of you have clients, it doesn't matter if it's an assignment, new construction, resale, whatever it is, just so you should be aware of that. We're trying to do our part for the community. We really appreciate the effort that these frontline workers have been doing. And we're prepared to reduce our fees by 25% to support them. So please pass that on to anybody that you want to. And again, while I'm still waiting for questions, thank you for attending.
David, if you have that, if you can forward that graphic to me, and I can share it on our closed group, so that anybody who wants to can advertise it on their social media too. And this way, put in we are doing partnership with Korman's, and this is what they're offering on deals. Might pull some business towards our agents as well.
Yeah. Okay.
Let's see, that's one question.
So I don't see,
Right. I don't see any
I
questions.
see one nice comment from
Yeah.
Laura.
Laura.
Lovely, David. That is wonderful of Korman's. So that's nice. Anyways, we're happy to do it. We're very grateful for those frontline workers. We're also very grateful that the government decided to consider you guys and our profession as essential workers. So we've been able to work right through this whole thing. So that's important too. So anybody have any questions?
I think this is it. So we all look forward to next week then, David. Thank you so much.
Okay, so same time next week, and I'll get you part one, the materials, so you can send that out, and then part two will have those materials that'll get out as well. And hopefully everybody comes in. If you don't have any questions, you can leave now. There'll be another opportunity next week, and be happy to answer it, or send me an email privately. You've got my contact information. Send me an email, and we'll get in touch, and we can deal on it privately as well. Okay.
Right, wonderful. Thank you everybody for showing up and attending.
Okay. Thank you, everybody.